I'm giving a couple talks in the next few weeks on harassment issues, and been gathering some things. We'll take advantage of that for next 2 or 3 videos. One of the things I think it's important for really all employees to understand is just the legal foundation of where we are in sexual harassment law, because it's all in the last 55 years or so. So there are just 5 key federal events, I think, that have us where we are now. Don't need to get deep into them, but ought to know what they are, because it is good background for some of the discussions we have on what we ought to be doing. So number 1, 1964, Title VII of the Civil Rights Act. This is the main federal anti-discrimination statute, and actually gender was sort of a late addition to that statute. It was primarily directed at race. So the Title VII prohibits discrimination on the because of sex under federal law, and most states have followed suit. Number 2, 1986, the U.S. Supreme Court in a case called Meritor Savings v. Vinson held that Title VII prohibits not just employment decisions that have economic loss attached to them, but also a hostile work environment that is because of sex. So that sort of really creates the hostile environment cause of action under federal law. 1991, the Civil Rights Act of 1991. Congress passes, the President signs, provides for a jury trial. It provides for damages other than economic damages. So this really makes a harassment lawsuit much more attractive to a plaintiff and a plaintiff's lawyer. So definitely drives these claims forward. Number 4, 1993. There's a U.S. Supreme Court case called Harris v. Forklift Systems. Really establishes, memorializes the severe and pervasive standard. We've talked in other videos. Harassment is not unlawful unless it's severe and pervasive. Sort of a necessarily gray term that courts work to define, but you should probably recognize those words from other videos and other things that you read. And then last, 1997, there were 2 Supreme Court cases. One, they're sort of referred to together as Farragher and Ellerth. Those are the names of parties in the 2 cases. And these were both harassment cases. And what these did was really sort of formalize the employer roadmap to defending itself against hostile environment harassment claims, underscored the importance of a policy that gave multiple paths for an aggrieved employee to report harassment in case, say, the supervisor was the problem. It couldn't just be that you go to the supervisor. The Supreme Court was very clear on that. The importance of training, the importance of when you get a complaint as an employer, you have to respond to it. So those, to me, are really the 5 big cornerstones of harassment law. Where we are now, we don't see much happening on the federal level. We see a lot happening on the state level in the last couple of years after Me Too, and we'll talk more about that in a future video.